Okay, I think we're close enough. It's my pleasure to call to order the Massachusetts Gaming Commission meeting number 34 on November 6th, 2012. Thank you very much for those of you who are attending. There's a lot of other things going on today. We're pleased that you were able to come visit us. We will start out with approval of the minutes from the meeting on October 30th.
Yes, Mr. Chair, Mr. Chairman, I distributed yesterday a revision of the draft minutes I distributed on Sunday, and the revision corrects the bountiful supply of typos and unintelligible sentences that were in the original draft. No change in substance, but I welcome any comments on the draft that was distributed yesterday, if there are any. Otherwise, I would move that the October 30 minutes as distributed and as part of today's meeting packet be approved.
Second? Second. Any more discussion? All in favor? Aye.
Aye.
Ayes have it. We're going to skip out of order here. I neglected to put on the agenda that we had asked the director of the Mass Environmental Protection Agency to come in. We've talked about it several times. Everybody's heard us talk about it. We had it scheduled for today. I forgot to put it on the agenda, but this is just going to be a learning session for the commission. We wanted to understand more about how the MEPA process works and have an opportunity to ask questions about it. So we're going to go ahead with that. There won't be any deliberations having anything to do with MEPA issues. It's simply the MEPA process for our own learning experience. So I'm going to ask the ombudsman to bring our guest up and introduce her.
Thank you, Mr. Chairman. It's a privilege to introduce Maeve Lily Bartlett to you. She's been the MEPA director since August 2011. I've worked with Maeve basically most of my professional life at one form or another. She worked in the Massachusetts State Senate for a number of different years, was an assistant secretary of transportation. She was an assistant general manager for environmental compliance at the MBTA. She served in an oversight capacity for transportation at the Executive Office of Energy and Environment prior to her appointment as acting MEPA director and now her full MEPA director role. Look forward to working with Maeve in the days coming up.
Excellent. Thank you very much.
Great.
Thank you for having me. Chairman Crosby had reached out to me maybe a month or so ago to just come and give a very brief overview of what MEPA is and what it does. I don't know if you've just sort of been hearing it, MEPA. So that was really the idea behind me coming here today.
From my standpoint, it's a big part of the community mitigation issue, and which is one of the biggest issues that we wrestle with. So as we're trying to figure out, what we need to do with community mitigation, we really need to understand what part of it's already going to be taken care of.
Right, because MEPA does have certain limitations around that. But why don't I give a very brief overview, and then we can discuss things like that if that is what you'd like to do. MEPA is an informal administrative process that is designed to examine environmental issues of, and I'm going to use the term large projects, although that is not necessarily the case. MEPA is projects that receive state financial support. They receive state money, or they require one or more state permits or approvals and exceed the MEPA thresholds. Then those projects are required to come to MEPA with the filing of what we call an environmental notification form. Many projects...
From the project?
MEPA is project proponent driven. We never go out and find anyone and say, you must come to MEPA. The attorneys and consultants who come before MEPA often are well aware of what the thresholds are and will direct someone that they need to come to MEPA. And the beginning of that, and I'll sort of lay out the typical process of what happens, and then obviously, much like any regulatory scheme, there are slight variations to how that can work. But in general, if someone is receiving state assistance, they trip a MEPA threshold, or they require state permits and trip a MEPA threshold, they come to MEPA with an environmental notification form that lays out what are the permits, what are the issues, how much land are they altering, that's a broad overview of the project. Then MEPA their thresholds have mandatory environmental impact report requirements or discretionary, the secretary's discretion to require an environmental impact report, and that would be the next step. Some projects just finish the ENF, have the ENF reviewed, and then we send them off to get their state permits. Other projects, the secretary at his discretion, or because the regs require it, will have to do a draft environmental impact report, and that is the first large overview of the project that comes to MEPA. That is a more extensive description of the project alternatives, the permits required, the potential mitigation, all of that goes into the draft environmental impact report. That then the proponent has as much time as they like to decide when to bring that back to us. MEPA never says, you must do your draft environmental impact report in a certain amount of time. It's totally on the project to decide when to gather all that information, how quickly, how deliberative to be, and bring it back. Again, generally what happens is the secretary then says, yes, that's the preferred alternative. Take that preferred alternative on your project and answer these last remaining questions and look at this mitigation or that mitigation. And that would then be done in a final environmental impact report. When the final environmental impact report comes back to MEPA, the secretary signs off on it or can require supplemental information. That can happen at the draft too, but if the secretary says, yes, all of the information is here and you have laid it out appropriately for MEPA, you now can go and get your permits. Often, the permitting agencies will refine that even more, and there may be more mitigation associated with that, or the project may be tweaked slightly. But for MEPA purposes, the broad brush is fine, and the permitting agencies have said they have enough information. So that's a sort of very general overview of how it happens. MEPA itself has strict timelines. Once an ENF comes into us, there are 21 days for public comment on that, and then the secretary makes a determination on it in 7 to 10 days. EIR, a draft EIR or a final EIR, gets roughly 28 days of comment, and then the secretary again has 7 or 10 days to make a decision. MEPA is very diligent and, as far as I know, has never missed any of those deadlines. Extensions on the public comment period can be made, but must be made by the proponent. The secretary himself cannot say, you have to ask for 2 more weeks of comment period. It has to be proponent-driven. Again, I've never known the secretary to say, no, you can't have any extra comment, and then that would be added into the timelines. But MEPA meets its timelines. It's up to the proponent how quickly to turn around the requirements that the secretary has asked for. Any questions on any of that?
What excuse me, that's a very helpful overview. What impact on the permit granting agencies does the MEPA final opinion have? Is it binding on them?
No,
Is it
no,
advisory?
absolutely not. There have been very few occasions. The one that leaps to my mind is Weaver's Cove, the LNG project that was, where the secretary's certificate said in the certificate, we do not believe this can be permitted, based on the information that DEP had given to us on how they were reading the permit requirements that that project would need. that still doesn't mean they can't continue to come to MIPA and get, review, but MIPA would never override permit requirements or the permitting authority of an agency. We are an informal administrative process. We are not a permit. MIPA is not a permit. It gathers the information, it assesses the environmental impacts in a public manner for public comment, and then the permitting agencies continue to have their own permitting authority, their own regulatory requirements that they need to act on.
So the MIPA, a favorable report from MIPA does not bind the permit granting authority either. The permit granting authority could say we disagree.
They could, yes.
Is it,
Now,
is it a
in that-
practical matter?
Maybe it has happened. I've only, been the MIPA director for about a year and a half. But certainly in the knowledge that I have, I've never heard of that happening. Johnny, you know of any?
No, go ahead.
I can't.
What is the other trigger? At the beginning, you said that there is a trigger, a large project.
Well, it's state financial assistance.
Right.
Or one or more permits required. You have to look at that.
Okay.
And then you have to see if a MIPA threshold is tripped.
Okay, that's
So
what I
you
meant.
could
What-
require, a project may need a permit.
Right.
But if it doesn't trip a MIPA threshold, you just go straight to the permitting authority and get that taken care of.
And in a broad sense, what are the MIPA thresholds?
There's traffic, there's air, there's solid waste, there's wetlands and waterways, there's historic, there's, I'm probably
Okay,
missing
so they're
something.
all, I'm sure they're all listed
Right.
in the statute. Yeah.
Right, and I think from when the gaming statute was first passed, many people asked me, what is this gonna mean for MIPA? And without poring over the gaming statute, my basic reaction was that my understanding of what these major resort projects are going to be, they are going to trip a MIPA threshold. It does not seem to me possible that the type of resort and project that is envisioned by the statute would not require MIPA review. And traffic alone is probably going to pull, even absent land alterations or wetlands or wastewater permitting requirements.
Are there any other thresholds that somebody seeking MIPA review has to meet? In other words, can somebody who has a plan for land but doesn't own the land, can
Yeah,
they?
MIPA does not require anyone to own the land. Certainly, the project proponent would be at their own risk.
Right.
Should they decide to do that.
Right.
But we have had occasion where we reviewed projects where people were in negotiations, or they were relatively sure they were going to own the land, or they were willing to take the risk to file with MIPA and go through the MIPA process, which is not insignificant or cheap.
On that note, what is your opinion, or how do you ascertain the level of design that projects generally come to MIPA? What amount of design, how detailed?
We don't put any requirement on a design level, but certainly to the extent, and this is, again, we leave this up to the person who has the project. Some projects, say you're at 50% design, and I've just made that up, you would be able to give more information to MIPA and the permitting authorities on what your project is and exactly how many wetlands you're going to impact, or exactly how much wastewater you're going to generate. Or the GHG impacts of your building, depending on the size of your building. What MIPA does in the absence of that type of specificity is to ask that the proponents give the absolute outside envelope of what it is that they could build, or even meet the zoning, what is the zoning cap on what you can build in this area, and look to the outside limit. Because if a project proponent does not do that, is at a level of design where they don't exactly know, and does not give us the outside limit, they're going to be in the position later on of having to come back to MIPA with what we call a notice of project change. And that starts the whole, some people have very small notices of project change on one sliver, and other people will come back with a redesigned project, and that just starts you over again on having to look at, do a draft environmental impact report and a final environmental impact report, depending on what the magnitude of that project change is. So generally, project proponents will give us that large envelope, and that gives you again, the magnitude of what permits you're going to need and what mitigations may be required.
Are the thresholds some defined level of activity, or is it if there's any traffic?
Oh, no, they're specific.
So there's some
Right.
description.
And most of them are linked, or certainly when the MIPA regulations were crafted, they were linked up to permit requirements as well. DEP told us what they would need, what the wetlands alteration would be before they saw something, what the Chapter 91 permits requirements may be before they saw something. Traffic is 3,000 and then 10,000. It's, there are limits in the MIPA regs as to what they are.
What's the point of this interim step? Why have MIPA do this as opposed to just having DEP go ahead and do it themselves?
Because what you end up having is a place where these projects can be looked at in total. So you don't have you don't have DOT looking at a highway access permit, and basically the public having to go and track down DOT's highway access permit regs and process and follow that and then wait a little while or keep tabs on when DEP's wetlands permit is going to issue and how they're going to make comment on that. So it brings everyone together more at a greater level for the totality of the project to be examined for environmental purposes before it spreads out and goes to the agencies. So we look to the agencies to make comments. So DOT will see the entire project that's come to MIPA and not just the traffic. And the same goes for DEP or natural heritage, their endangered species thresholds as well. They'll see it all. And I think that's just good for the permitting agencies and for the public.
Well, the EIR describes the impact and then the mitigation.
They
so
could
that-
certainly do that, yes.
But don't have to.
Well, it makes sense that they would lay out what mitigations would be, especially if what they're going to do is have, at that point, they may not have decided exactly what the preferred alternative is. So if you come in, a project comes in and has 3 alternatives, just say they have a 10-acre site and they could put the building on the west 5 acres, or they could put the building on the east 5 acres, or they could go straight down the middle, and there are various impacts depending on where they put it. Once comment comes in from the, and say DOT says, well, you can't possibly put it on the west side of this 10 acres because the impact to route blah, blah, blah will, but, the middle, it allows both the proponent and the permitting agencies to look at the various alternatives before one preferred alternative is honed in on, and then that becomes what the final is about, and that becomes where the permitting agencies can really determine what they need, and the public and the permitting agencies can request various mitigations.
So the comment is only from the permitting agencies?
No, the comment
Not
is
the
for
public.
everyone.
Okay.
But we rely on comments from the public and all people, but if it's DEP that's going to give the permit in the end, clearly we give weight to what they say about how they would look at a project. But no, MIPA is, everyone can comment on the
So,
MIPA process.
I'm sorry, so why would the proponent request more time for the comment period?
Potentially, you could have, there are lots of different reasons why it happens. Often, it's a controversial project, and 28 days may not be thought to be enough for people to really examine. These documents are extremely large. T projects, for instance, let me just choose the Green Line extension. That's an incredibly detailed project that went through a number of towns and was politically charged. So the T said, let's make it a 45 day comment period to give people more time to examine this large document and comment to the secretary on it.
What's the public hearing process for,
We do not have a public, oh,
but, I mean, you put out the comment period for the ENF and the AIR. How does the public, okay, they view this document, I've seen a couple of ENFs and the AIRs, they're pretty substantial. Are there any requirements to do local hearings or local
No.
comment periods?
no, we have what's called the MIPA monitor, which many people are very conversant with, certainly people who deal with the large projects and the larger advocacy groups, or even the smaller advocacy groups are well aware and are on the MIPA monitor list, and they will be alerted to projects that come into the MIPA monitor. People will look through it, and they will, right in the monitor, it will tell you what the comment period is and when the comment period closes. We often, though we are not required to, do site visits when we first receive the environmental notification form. But the site visit is not a public hearing, and we are not required to take notes, keep a public record, and at those site visits, we make it extremely clear that it's written documents to MIPA that puts you in the queue. Proponents need to respond to public comment. That doesn't mean they need to write to every single person individually. They have to have a section of their draft environmental impact report and their final environmental impact report that answers the issues that arose in the public comment period. It's also MIPA could have a public hearing, and certainly MIPA has had public hearings in the past, but it is not required. It's a written public comment system.
We've had numbers of conversations with regional planning agencies, and they have offered to help this body in terms of assessing projects, giving thoughts and feedback on projects specifically to the mitigation piece. They shared the example of their relationship with MIPA in terms of providing some local comment, local feedback. Can you just give us an idea what the mechanics are of that relationship and what they are required or not required?
They're certainly not required to do anything if they don't wish to, but again, the regional planning agencies are used to the MIPA process and are savvy about the MIPA process, so they will receive the environmental notification form. And just, people hear things, the sort of buzz would be that, and oftentimes the proponent will tell people, we're going to file in this period of time. And then they make comment to MIPA in writing, the same way anybody else does. We don't have a formal agreement with the regional planning agencies.
And the ENF and the EIR are multi-jurisdictional. I mean, you cross wherever there is an impact, not just in our lingo, not just in a host community, but it would be in any surrounding
Anywhere that
communities
there
there's
is an impact.
Okay. So if Are there significant areas of impact on a community that are not included? And if you're a community and you want to make sure you've thought through the impacts of our big projects, are there areas that are clearly not
Well,
within the
well,
NEPA?
Yes, thank you. Certainly, we are not, we have no jurisdiction over public safety in the broad sense. Certainly, the roadways are extremely important, and waterways, but the police, fire, schools, we have no ability or jurisdiction to say you must pay for police details, that type of thing. The mitigations are related to the environmental impacts, and that will then be translated into a permit that would also require that mitigation. There are some tweaks to that. If it's GHG related, we require
GHG.
greenhouse gas emissions. If you're building a new building, we like to see the energy efficiency of it. We like, in transportation, we like to see anything that can be done to reduce the traffic and the GHG emissions from that. If it's traffic related, the mitigations can be incorporated into the DOT access permit. If it's building related, we will require the project proponent to self-certify to MEPA that they have met their mitigation requirements. They do their own Section 61 findings under the building efficiency. But we do hear often, we're concerned about, we had the Taunton proposal in front of us as an ENF, and we heard from many people that they were worried about fire and safety and social services. And we have, that is beyond the bounds of MEPA. There are other issues that may be municipal related that MEPA also has no ability to require of a project proponent.
Like municipal roads, for example?
Municipal roads, municipal services, sort of the plan, if a municipality has a plan on how many trees they want in some area or what their local parks requirements are, if there's no state jurisdiction over the land, then we really can't require a municipality to do something.
Now, the one in Taunton that I heard about was the NEPA process. I didn't know the national environmental policy. How do how does MEPA and NEPA relate?
Well, there are also very different ways that people can, oftentimes, if the Taunton proposal needed NEPA review because they were seeking under the federal process, right, to have the lands placed in trust, and there would be various issues there. So that brought them together. They, they were not looking to link the processes up. Some proponents will do that. The ones that I am most familiar with, aside from the Taunton proposal, are the large transportation projects, such as the Green Line or South Coast Rail, or major roadways where federal funding is being sought and a federal requirement sends you in to NEPA. And in those instances, DOT has often tried to link them up, so had a joint filing. So the draft environmental impact report and the federal environmental impact report, FEIS, FEIR, they would be one document just sent to both entities.
So typically, in our projects, the NEPA would not be involved. It would only be a MEPA process.
I think that it would.
Probably.
Yeah.
Right, okay, I didn't understand that.
Just to come back to Chairman Crosby's question a minute ago, there may be not only interest but permits that are required but that are outside the MIPA sphere of influence, if you will. The building permit, for example,
Yes.
is not within the MIPA sphere of influence. If someone wanted to build a racetrack, they'd have to come to us to get an operating permit. That would be outside the, so typically.
We certainly don't have any thresholds that deal with,
With those kinds
Right.
of things, right. Do you have any feel for how many local or how many permits outside the MIPA sphere a typical large project requires? Does anybody get a
I
handle on
don't,
that?
I
Yeah,
do not know
yeah.
that.
Okay.
Has there been any of the current proposals about casinos come to MIPA? bes-
No,
to
the
your
Taunton
knowledge?
proposal was the only one that
The other one
we
that
have
you're gonna-
seen. Oh, we have Plainville. Plainville came in, and they have been scoped for a DEIR based on the traffic projections. They stated in their filings with us that they were going to seek this, I think it's this stage 2 or something, the
Type 2
slots.
license,
Slots,
yep.
yeah.
Right.
And that's why they proactively came to us on that issue.
So in the Taunton MIPA process is underway now?
They have been scoped for a draft environmental impact report, yes.
Right, okay. And that's operating in parallel with the NEPA process, which is
Yes.
also going on? Okay. Okay, great. Go ahead.
Well, your question initially, we should talk about either, relative to the mitigation piece. It occurs to me that the review, and maybe it's incumbent on this commission to make that a requirement. The MIPA review, prior to the obtention of the license, would be a scheduled requirement.
Well, that gets.
I'm sorry, not the obtention of license, the mitigation agreements, the local mitigation agreement.
The host community agreement.
The host community
surrounding
agreement,
agreements.
yeah, and the surrounding community agreement.
This is something that we haven't really talked about, and I don't know very much about. You know, there's a question, and I think in our policy questions about where in the permitting process will we require bidders to be before we will grant licenses. And does that sound, you know, we don't have to decide this right now, but is that, to you too, does that sound reasonable, John, that we would say that you would need a MIPA approval, not necessarily all the license approvals, before a project comes to us for phase 2?
I think we'd have to think about that. You know, one of the, when I give my ombudsman report, one of the concerns that I hear out in the community is that that we give people enough time to comment on some of our policy questions. And for project proponents, the ability to go through the state environmental processes or other permitting processes, there's a big interaction with what happens at the local level, obviously. So in projects of this scope, you want to have enough certainty that you are proceeding along the way with the local community before you engage in a tremendous amount of your very expensive permitting processes. So that's sort of a very long-winded way of saying, I think I need to think about that a little bit more.
One thing I probably should have made clear very early is that proponents are not allowed, cannot get a state permit until they have completed the MIPA process,
A state permit for what?
for anything that is required under MIPA. If you're in front of
for any-
MIPA.
okay, you can't-
Right,
you
no,
can't
it
get-
could be,
Yeah,
right. You need to complete the MIPA
Right.
process. Now, that can be simply the filing of an ENF before you can obtain your state permits. You can apply for state permits while you're in the MIPA process, but you cannot receive a state permit until you have completed it.
yeah. And this is just a big one we're gonna have to think about. There's a whole lot of questions where they're gonna
Right.
be in the state, in the process, every process,
Yeah.
design process, permitting process, and we're gonna wanna
Right.
hear from the bidders too.
Yeah, and with our bifurcated licensing process, you know, some of the deadlines that we've been talking about would apply to the first stage versus, you know, the final license being issued. So I think we need to think about that.
Right.
Yeah, but it occurs to me that an important point of data for host communities is going to be, at a minimum, the draft environmental impact, but hopefully the final one would be that much better, more information.
Correct. Yep.
Better source to mitigate the impact that's assessed.
Well, this is the thing we've been talking, you know,
Yeah.
what if if you have a host community agreement which presumes some environmental permit, and then there's a referendum on that host community agreement, and then the permit isn't granted, you know?
And then what? I'm
And
sorry.
then the permit isn't granted.
Right.
Then do they have to renegotiate, revote, and will we award when there is a big permit that is pending? Because if we do, they might not get it, and then what happens? So those are just, they're rhetorical questions at this point, I just don't know exactly. But there's also part of the issue about the tie to community mitigation. This is something you'll have to help us with, is some of the communities, I think, are thinking about our bucket of money to be the source of mitigating community impacts. There are many other mitigation buckets of money before you get ours. We really want ours to be a court of last resort, you know, for things that really weren't anticipated, that are much worse than thought, et cetera. And by being really thorough in, for example, their MEPA process and making sure that the developers have all the appropriate remediating mitigation steps in the, you know, in the pipeline, that will minimize them coming to us and say, oh geez, we forgot to ask the developer to do such and such. Same with the host community agreements. So, you know, it's important, we want to make sure that the communities are really paying attention to all of their other stages in the process to get things fixed and paid for where necessary.
Right, and communities obviously should take into account project estimates versus potential for overruns of project
Yeah.
estimates, and how that is accommodated if a developer X has proposed a mitigation package. What would happen in the event that project costs
Right.
go beyond that anticipated amount? And does that impact what would happen to the overall project and its success?
Right. Right. Any other questions for the commissioner?
No, that was very helpful.
Yeah,
That was
great.
very helpful.
Thank you very much.
Yeah.
We'll be talking, no doubt.
My pleasure.
Thanks, Bev.
Thank you.
Okay, we are back to item 3, the project work plan, and we're going to go to the consultant status report.
Good afternoon.
Good afternoon. Do you want to introduce yourselves? and-
Not as important.
Yeah, the guy, Michael and Carol?
Bob Carroll, Michael and Carroll.
I think we're starting out by getting a report from you on the scope of licensing meetings.
All right, we had scheduled and were met with a series of interested parties today. I will go into the identities of them, and yesterday. The purpose of these meetings was to start the process of identifying those persons and entities whose qualification is a necessary condition to the qualification of the applicant itself. All of these licensing decisions are made on the basis of the persons who give the entities its direction and its control and who benefit from it. So the first stage in evaluating any applicant is to identify who those persons are. The statute and the regulations go into some detail in identifying officers, the categories of people and entities that need to be qualified: officers, directors, owners, and in almost every instance, the owner of the applicant will be another corporation, so you go through the process all over again of identifying those officers, directors, and owners of that company up until you get to the ultimate owner. In some cases, that can be a simple process if it's very clear who the people are who are giving the direction and controlling the entity. But in some cases, in many cases, the corporate structures are quite complicated, and so it becomes, to some degree, a matter of discretion in evaluating who are the people that are most important to the project, who should go through a background investigation, and who are the persons who really do not need to. The statute and the regulations give this commission the authority to waive qualification for certain people who might otherwise fall within a category that required their qualification, but who it can be demonstrated by the applicant are not those who are really involved in the project here in Massachusetts. For example, there can be corporate vice presidents of development who are segregated by sections of the country, and their area is not near Massachusetts at all. They're working on developments in other parts of the country or the world, and even though they have a titular facial obligation to qualify because they're corporate officers, their involvement here is negligible if existed at all, and so they can be waived if it's demonstrated that they meet those criteria. So we had these meetings, and what we sought to do was to identify each of those qualifiers in each of the individual groups that we met with, and to the extent that we could not agree on the people and the entities who needed to file, we set up a system whereby we identified those persons who are facially qualifiers but who can be waived, and if the interested parties, the applicants and other interested parties wanted a waiver on those persons, they are required to submit to you a written justification for those waivers by no later than next Friday. Then the consultants will meet and evaluate those requests for waivers, provide you with recommendations, and you will make a decision on whether or not there is a sufficient basis for the waivers to be granted. So most of the parties, all of them, were very cooperative. We will probably be receiving some waiver requests, and almost all of them said, to the extent that they were going to submit some, that they would do it as quickly as possible, maybe even before next Friday. So we consider the meetings very productive. A great deal of progress has been made as a result of them, and we're looking forward to continuing that process. So Bob can let you
By
know.
next Friday, did you mean?
The 16th.
The 16th.
16th.
A week from this Friday.
I'm sorry, yeah, week from this Friday. So you can identify.
For the purposes of identification, the consultants or component groups of the consultants and commission personnel met with the following groups: the Plain Ridge Race Course, the Caesars Suffolk Team, Mohegan, Ameristar, Massachusetts Gaming and Entertainment LLC and its affiliate Rush Street Gaming, MGM Springfield, and Penn National. As guys indicated, we spent time with them reviewing their submissions as well as reviewing their questions. And we now have a schedule in place. We expect very aggressive compliance with that. We'll examine those submissions as soon as they come in, and then obviously recommend to the commission our viewpoints on it, and then expect that there'll be a timely scheduling of your review of those, and then ultimately a decision.
Just want to put this determination, even when it's made by you and as a determination on the waivers themselves, is a preliminary one. In the course of the background investigation, it may become apparent that there are other people who haven't otherwise earlier been disclosed who we think need to be considered qualifiers, and if that's the case, then you would have to make that determination as well. Or we may find that at this early stage we overstated the participation of some of the people who we now deem to be qualifiers, and we may decide that they don't have to. But this is, at this stage, this allows those applicants who choose to apply to prepare their applications, know who they have to file for, and get them in as quickly as possible.
For those who are here and those who are watching, it's my understanding that these meetings were entirely voluntary.
That's correct.
Nobody was required to attend them, and nobody, and people, if they wish, are perfectly free to file an application by January 15th without ever having had one of these meetings.
Absolutely.
Just
Absolutely.
proceeding by themselves. So this was a service done to
Correct.
help those who wanted to avail themselves of it, nothing more, nothing less.
Right. And I would expect, correct me if I'm wrong, that if another party comes in later and desires to have a similar meeting, that we'd be available to do that as well.
And the qualifier list could expand later in the game if, when financing comes together, there are new
Correct.
parties, then we would automatically
Correct.
extend it to those people.
That's right.
We explained all the variations to the various participants, and I would say we had a strong pledge of transparency by every group that we met with. They understood the rigorous nature of the statute and its application. Most of them are industry veterans, and we were very satisfied with the cooperation we received.
And nothing should be read into the fact that some companies may be seeking waivers on some people. It's not an intention on their part at this point, we would think, to hide anything from the commission, but it's an arduous process, and if there are people who really are not going to be involved in it, there's a legitimate reason for seeking the waiver.
We often hear of stories where these are very contentious and you get into extended back and forth and litigation sometimes and so forth. To the extent you can tell, you don't see that. This looks like we're not likely to have, so far, it looks like we're not likely to have any serious hang-ups in the definitions of qualifiers.
At this point, I would think not. There are actually very few where we weren't in agreement on almost everything. And to the extent that there was some disagreement, we weren't the only jurisdiction that had that disagreement, and some of it has been resolved in the past in a certain way, and they'd just be requesting that this commission give it another look.
Just also for clarification, expounding on Commissioner McHugh's point, the deadline for waivers is this coming Friday, but only for those who sought this initial meeting.
Yes, correct.
Assuming that somebody else seeks a meeting after that, there would be similarly the same
Exactly.
type of process.
Yeah, it won't be cut
A
off.
meeting and a waiver if so desired, correct?
Yes, just for the people who we met with in the past 2 days, and
Right.
it's the deadline for the request for the waiver, not necessarily for the waiver.
Is there, from the meetings that you've had, and obviously we have a number of established institutions who are finding local development partners, did you get a sense that the local development partners are acutely aware of what their requirements are going to be on their behalf?
Yes, in fact, we were pleased with their understanding, their level of understanding, even at this early stage.
Yeah, they all came with very complete and thorough presentations to us, understanding what the categories are and what the needs are, and we made the job much easier.
Did you provide some kind of a template to ask for a waiver, or just clearly articulate what they need to include in that?
We cited the
request?
statute and the applicable regulations and so forth, and in most cases, they were aware of what would be required. Part of the resubmission that'll be coming back to the commission will be the different categories, as guys indicated, and we have substantial agreement on most. And the ones that we don't, then we actually discussed the specific reasons, at least preliminarily, that we would expect them to address in the letters. So they were given specific instructions.
Outside of the waiver process, you also had discussions about the application process and specific questions?
Well, we advised them that there's no delay in filing applications either. If they would like to, the specimens have been out there, the phase one application.
Yes.
We told them there's no delay. I mean, they could file tomorrow if they'd like. And they understood that, but obviously the qualifier phase is a precursor in most cases to their putting together their applications. But they also indicated in several of the cases at least that their applications are well underway in terms of preparation. So I would expect submissions are not going to be that far off.
And actually, one of the purposes of these meetings was to identify people we have no disagreement on, and as Bob said, we told them that you don't have to wait until you find out if others are going to be waived or not. If those qualifiers who have already been clearly agreed upon, they can file immediately, and then others will follow after that if necessary. But one of the goals of this meeting was to allow the interested parties to get their applications in as soon as they can.
Excellent.
Part of what you were going to explain part of the public presentation we're going to have back on the 29th, before Sandy disrupted all of our plans, included your public comments to, not only the general public, to the general public as well as the potential applicants and developers. Is there any information you would share with us, or you think that you've missed that would be important for the public at large to know, since we had to skip that public presentation?
Yeah, good question, thank you.
Yeah, I think it's important to understand that what the goal of these initial meetings is to make sure that this commission is fully cognizant of all the aspects of an applicant and an applicant's organization that makes it go. So that the decisions that are made in this Phase 1 process about who's suitable and who can get into the Phase 2 process is thorough and is well reasoned. To the extent any individuals need to be excluded from, or can be excluded from that process if they otherwise might be qualifiers, it's only because they do not have a role in this particular project that really would have a bearing on the suitability of the applicant itself. If we do, and we also have to keep in mind when we go through this determination process on who has to qualify, that we don't want to be over-inclusive either. It's a burden on these applicants to file all this information. And then it becomes an administrative burden on the commission to conduct very thorough investigations into people who may not have any real relevance to the Commonwealth. So there's a balance that has to be struck as between what's necessary for a thorough investigation and what's necessary so that the administrative process can proceed efficiently. And that's what we're trying to accomplish.
I think the only other thing I'd add, Commissioner, was, we would have explained to the public probably in a little more detail, but that, as Commissioner McHugh has indicated, this was a service that we wanted to extend to the applicants, to cut down some of the time with, say, a raw submission of an application with no determination, no suggestions other than what was in the cold statute, so to speak. This way, we believe we've cut off delay. And we know that is part of the mission, and we think that getting some of the questions, some of the basic questions answered that some of the applicants had, it did facilitate that objective, and that was one of the objectives we would have announced to the public of the purpose of the meetings.
You also distributed the ethics advice.
We did. The ethics advice, actually copy of the portions of the statute and regs that applied, were also given to each applicant.
Now, can you just make sure everybody's on the same page, just describe the rest of the process? So a package comes in, then why don't you walk through the rest of the process here?
Well, at this point, there would be two paths, I guess. One would be that anyone who is interested can, if they haven't already applied, apply for their license and submit those forms that we are all agreed are necessary to be filed, all those qualifiers that have been identified. To the extent that there are individuals or entities that any of the proposed applicants or applicants want waived, that needs to be submitted to us by the 16th, and then a determination will be made on those. With respect to the applications, once they're all filed, what would then happen is that they would be referred to the IBE for investigation, and then either staff or a third-party contracting consultant who would be conducting the background investigations would begin right away in first reviewing the applications themselves to see if there's anything that stands out in the form application and determine that it has to be looked into right away, or and a financial evaluation of each individual for a source of funds analysis and for a financial stability analysis. And then what often happens is the investigators prepare a form list of additional documentation that's necessary beyond what has been submitted in the application. That's why we say this is a fairly arduous process. requests go out for checking accounts and other bank account information and, the stock ownership and real estate ownership and deeds and mortgages and a very thorough investigation into a person's background. Those are then reviewed, and as necessary, the individuals are called in for interviews to go over any matters that create any problems or create any issues. If there are questions and issues that need to be even further pinned down, it's not unusual for the applicants to be asked to come in for a sworn interview in the nature of a deposition, in which those individual questions will be addressed, and the applicants be required to swear to the truth of the responses. And then an overall evaluation of all of that information is made by a supervising investigator who actually has been overseeing the process all along, and then an attorney who would evaluate the information in relation to the standards in the Act and the regulations, and the Deputy Director of IBE would then make a determination on whether or not those individuals are suitable. If they are found not to be, there is an appeal process by which those individuals can request a hearing, first before the Deputy Director of IBE, and if unsatisfied with that result, before you.
And if somebody, when a package is submitted, if somebody doesn't have any waiver requests, and a package is submitted, does that get reviewed by you first, or does it come straight to the IEB and we're off to the races?
It goes to the IEB.
Okay, so you're, unless there's a negotiation over a waiver,
Right.
you're out of the process at this point. You've done your voluntary meetings,
Right.
you've done your service.
Right.
And as soon as they come in, we're ready to go.
Right.
And if somebody has on a waiver that's being discussed, is there any reason why they can't submit everything else and we get started on
No,
people?
in fact, that was
Yeah.
one of the
Just
points,
talk
yes,
about-
we want
Okay.
them to do that.
Okay.
They don't have to wait for the entire package to be complete. They can submit in piecemeal, if you will. But in terms of the role, one function we may serve before it goes to IEB is just to review the application, make sure it's complete, that all the information that they said they would submit, they have
I
submitted.
think that does make sense. So
Right.
there is an interim step that
Right.
goes to the consultants,
Right.
back to the
Yeah,
consultants.
and there's a legal significance to the finding of completeness of the application, too. That's an important milestone in the process.
In the statutory process?
Yeah.
So that probably has to be certified by the IEB, not by the
Well, it
consultants.
would be, yeah.
Yeah.
Exactly, yeah,
Right.
we're talking. But I mean, the
Right.
completeness of the package that ultimately comes for your review
Right.
is a finding that we made.
Right, okay. We have talked about this a little bit, but, and it's the last couple of weeks, I think we've been talking about standing up the IEB in a formal way so that it can take whatever official steps it needs to take to certify completeness of their packages and begin the process. We are still in the interviewing process for directors of IEB. We're hoping to coordinate it with the ED, which was also in the process of interviewing. And I think it would make sense, now that she doesn't have anything to do, we got rid of racing and dumped it on Dr. Dernberger, that I would suggest that we designate Commissioner Cameron as the director of the IEB and authorize her to take such steps as are necessary to get it up and running, to collaborate with the consultants, to get the personnel in place to make the right steps. You're starting to have some staff, you're gonna have 2 staff coming on board anyway. And you've got some relationships with the state police, so you give Commissioner Cameron the authority to structure the IEB under her in a sort of a tentative way, so we can get this started as soon as the packages start to come in, which could be any time now.
Correct.
Does that, you guys, anybody have comments or thoughts on that?
I would agree with that notion. The IEB is standing up and is clearly on our critical path. And while I know there's been some progress made on the search for that director, I think it's incumbent upon us to have something in place for the possibility of receiving some applications for some qualifiers early, which is what we want them to do, so that progress can be made as well.
Right.
So,
Anybody else have thoughts about that?
Well, I was just, I haven't thought about that until this minute, and I was trying to quickly look at the statute and see whether there's anything in the statute that would suggest that we can't do that. Well, if we get something next week, say, there's nothing that says we have to start investigating it then, as opposed to putting it to one side until we get the IEB stood up, right?
No.
I don't know if that's a good idea, I'm just trying to probe. There's also nothing that prohibits us from creating a acting director of the IEB. We know, for example, who's going to be the state police liaison to the IEB, right? Or the state, do we know that?
Well,
Not liaison, but the IEB is going to have a state police component. right?
correct, they are. There's our tentative, and I say tentative because everything we do is subject to change according to if we see a need to change it. But our tentative table of organization calls for a director and then a state police captain underneath that director, along with a chief investigator. I have had, the state police has named a major to be our overall contact, and he is an individual who has helped us in a number of areas already, but he will oversee gaming in its totality, including the responsibilities at the Attorney General's office. He has spoken to me about, he's given me a preliminary name. Now, I don't know that that's agreed upon yet by the colonel, and we have yet to interview that person to make sure we're all in agreement that's that person, would be acceptable to all. So, to answer your question, Commissioner, I don't think it's finalized yet who that person would be. But we're moving, if I were to take this role on a temporary basis, by the way, I'm more than willing to do it. I see the need to move this and not sit on investigations, but I think we're very close to being prepared to conduct investigations with a third party. I think we're very close to identifying finalists for an IEB position, and moving along with the state police as what their role will be and who those individuals, what we're going to need immediately. So, I see this as very temporary, but certainly something I'm prepared to and willing to do under the circumstances.
Well, I have great confidence in everything Commissioner Cameron does, and I have no doubt as to her ability to do this. My concern is that the director of the IEB is going to have to make some decisions conceivably. Once the IEB exists, then the IEB head is going to have to make some decisions, and those decisions then are going to be appealed to us by by unhappy folks. And then we need to have a decision at this level as to whether or not the appeal should be sustained or not. Having made the decision, Commissioner Cameron would be disqualified from participating, which would leave, among other things, a four-person board to decide these things. And second, we'd be deprived of Commissioner Cameron's insights into the appellate process. So I am reluctant to go down this path unless we absolutely have to, for those reasons.
In regard to those concerns, to the extent that it might be relevant to you, it is not unusual in a gaming regulatory process for commissioners to sit, for example, as hearing officers, and then to have the matters that they sat on heard by the commission, even to have those commissioners who sat on the matter vote on the matter as part of the commission.
Including what we do with the racing commission, right?
Correct.
So there is a precedent for it not necessarily requiring the recusal of Commissioner Cameron if she were to serve in that role.
The other piece of this is, these investigations are complex, timely. I really don't anticipate serving in that role long enough to have a challenge, to a suitability challenge at that point.
No, I'm sure we wouldn't get to the suitability challenge, but we're going to get the waiver requests here in a week, right? Somebody's going to make a decision initially as to the waiver. That would be the head of the IEB. And somebody's going to be unhappy about the waiver decision is going to come to us. That's inevitable. It's going to happen. It's going to happen within.
We had anticipated that the waiver request would come to the commission at this point, not necessarily to the IEB. That it would be the commission really has to determine who are qualifiers and who aren't. And so we had advised the parties that their information would be supplied to the commission and it would be public and that you would make the judgments.
Our timetable, if you will, was that by the 16th, at any submissions they had, we urged them to get it in right away, and we got, I think, a commitment that it was going to be very quick. We would respond, we were going to allocate, 2 weeks for responses, research and responses. But again, we think that would also be accelerated, and then immediately turn over the recommendations to the commission as a whole, with a target date being, I think, December 11th is the outside, and perhaps even as early as the 4th, depending on the timing of this. So that there'd be very little delay here. So from the point of view of commencing an investigation, the qualification should be resolved by then, if that makes any difference to your thinking.
I mean, you certainly could have the IEB do it. It would just, our view, and you can reject it or accept it, is that it would expedite things, because ultimately it will come to you anyway. They're not going to be, if they're not happy with the waiver determination, they're not going to just rely on what the IEB says, and they'll take every opportunity to exhaust their remedies. So it will come to the commission anyway. Figured we'd just skip the intermediate step.
My sense, I think this is very well taken points and worth thinking about. These things are always trade-offs of imperfect options, but in my mind, this has been a very plausible scenario for a long time. If we didn't have the resources at hand, that would be a different story. If we were talking about making me the IEB, that'd be a different story. But we happen to have somebody as a commissioner who is as good as any of the people we're interviewing.
Well, there's no question about
Yeah,
that.
I understand. And that then, and we have structured on purpose a relationship with consultants who can work with this person ASAP, whether it was a commissioner or the actual director, even before there are full-time staff. So taken all together, it seems to me that the opportunity to keep the ball rolling quickly outweighs the somewhat, the residue of the points that you make, Commissioner, which I think are good ones. But I think we just probably. The waiver idea comes straight to us. That was your suggestion anyway. That it deals with Commissioner McHugh's concern. Chances are pretty good that we will have the director on board before the investigations are done. So that would moot the other point.
Yes.
And if not, we talk about it at the time. Other thoughts or comments?
I already stated my position.
Right.
Which just underscores by the comments made.
Right. And it's an opportunity for us to make up a big chunk of time in our time frame without, I think, a serious sacrifice, which is an important part of our goals here. Does somebody want to move? Not me and not Commissioner Cameron, I guess.
I'll move that we designate Commissioner Cameron to be the interim director of the Investigations and Enforcement Bureau until such time we designate a director.
And authorize her to take such steps with the state police, with the consultant and others to move the investigations process forward.
Well said.
And report to us accordingly. Does that make sense? Second? Second. Any more discussion? All in favor?
Aye.
Opposed?
No.
Motion moves, passes 4-1.
I know.
Okay, we have the RFA 2 process, which we need to talk a little bit about, just make sure we're up to speed here. Then you're not planning on staying here while we talk through the policy questions, or are you?
We can, if you would like us to. We already voted, so.
You already voted. Well, it might not hurt, but what I'm thinking is our guests from Jackrabbit are here to make a presentation, and I hate to have them have to wait through what could be a quite long conversation through these
Okay.
46 questions. So if you wouldn't mind, let's stop, ask Director Driscoll to bring her team forward,
Okay.
and we'll bring you back.
Okay, thank you.
Thank you very much.
Mr. Chairman?
Yeah.
Can we get a break?
Break,
at some
yeah,
point?
and we'll take a quick 5-minute break while they set up, okay?